Good morning, everyone, and thank you for joining us this afternoon, or good afternoon, everyone. Sorry. Thank you for joining us. My name is Taisha Preston, and I'm the administrative assistant for SCMA. Welcome to today's webinar, SCMA's Attorney Outreach Committee's Attorney's Beginner's Guide to Mediation. This webinar is eligible for 1 MCLE credit and 1 hour of MC3 continuing education credit. If you are requiring MCLE credit for attending this event, please check in by putting your name and your state bar number in the chat. Please make sure that your name is spelled exactly how it is connected to your state bar number. There are some handouts to this webinar, which I will be providing along with a link to the recording shortly after the webinar. And before we introduce our moderator for the day, a word from our sponsors.
Are you ready to launch your mediation career? With the courts more backlogged than ever, and most cases resolving outside of the courtroom, now more than ever, there is a need for skilled mediators.
There is an opportunity to make a difference while also making a living in a fulfilling career.
Hi, I'm Jennifer Tarando. I'm a registered nurse, an attorney, and a mediator, and I focus on mediating civil cases with medical legal issues.
And I'm Leila Balakane. I'm a family law mediator specializing in child-focused mediation. Jennifer and I are incredibly excited to present Mediation Mastery, 40-hour training designed for both new and experienced mediators. Our aim is to equip you with the negotiation skills, the ability to mediate any case, and effective strategies for high conflict disputes.
Mediation Mastery has been approved for 37 hours of California MCLE and it's DERPA compliant. It begins on January 7th, 2025, and will run on Zoom throughout the month of January. Mediation Mastery will then culminate in a 2-day in-person summit at Alternative Resolution Center's downtown Los Angeles office. Mediation Mastery is very proud to collaborate with ARC.
Mediation Mastery includes live sessions with 8 leading guest speakers, pioneers like Chip Rose and Bill Eddy. At ARC Summit, we will have 4 ARC mediators who bring invaluable real-world insights covering a range of topics.
Not only that, we'll teach you how to launch and market your practice through a series of boot camps, but we don't stop there. We also offer post-training coffee chats to answer your questions and support you as you launch your practice.
Our vision is to create a lasting community of mediators, a network that supports and grows together long after the training ends.
If you're ready to launch your mediation career, scan the QR code and register by December 27th to take advantage of our early bird pricing. Also, check us out at 40hourmediationtraining.com and follow our LinkedIn page for mediation content. We can't wait to meet you.
And thank you to Mediation Masters for sponsoring this webinar. And now I would like to introduce our moderator for today's webinar, Mr. Daniel Epps.
Welcome again. I'd like to introduce our distinguished panelists for today. We have Mark Kramer. He is a mediator with ADR Services. He practiced law for over 40 years before becoming a full-time neutral. He is a super lawyer, both as a litigator and as a mediator. Jennifer Tarando has 20 years of experience both as a licensed attorney and as a registered nurse. She has a robust legal career that has spanned multiple medical-related subjects. Her primary focus today is in nursing home disputes, and she was the 2023 president of the SCMA, which is the organization that's presenting today. This is a webinar format today, so we cannot see or hear the audience. So please use the question and answer section below, and we'll get to your questions toward the end of the program. All right, with that, we'll begin. I'm going to put up our slides here, and Jennifer is going to be leading with a discussion about the fundamentals of the mediation process.
All righty. Good afternoon, everyone. It's great to be here. So the the topic of our webinar is the Beginner Attorney's Guide to Mediation. And I always like to joke because when I started out as an attorney and I was covering mediation, I really didn't even understand what a mediation is when I first started. And so this is to, I know law schools have gotten much better and there's a lot more education on ADR nowadays, but I was really, I was well-versed in litigation, but not the mediation process. So we're going to start with a very brief overview. I know people that are tuned into our webinar have all different levels of experience in mediation, but I always think it's good just to start with a very broad overview of mediation, and then we will dig in a little deeper. So mediation, by definition on our slide, is a confidential setting for problem solving. When I work as a mediator, I'm usually tell the parties in my opening statement that really what I say mediation is we're pausing the litigation process to see if we can get the matter settled. And how does mediation work? We can sort of move on in our slides to the anatomy of the process. So just very basically, if you are going to a mediation as an attorney, what does it look like? And so the first comment I guess I should make is that, up until 2020, mediations were in person. There were, of course, Zoom mediations, but those were practically unheard of. And I like to reflect back on the mediations being in person, where there would be several conference rooms and the process would take place usually beginning in an opening with all the parties and then going into all the parties moving then into separate conference rooms or caucuses. That for the most part occurs on Zoom nowadays, although the joint opening session seems to be disappearing, at least in the Southern California market. Most parties are today, whether it's an in-person mediation or on Zoom, starting in caucus sessions, which are individual breakout rooms. So in person, that would just be starting in separate conference rooms and the mediators moving back and forth, or on Zoom. I do primarily all Zoom mediations. I bring parties in, I have my breakout rooms ready to go, and I put parties and their attorneys in separate breakout rooms, and then I move from breakout room to breakout room. Occasionally, parties can come together for a joint session. Sometimes attorneys come together for a joint session, but for the most part, I would say, and anyone that, Mark, Dan, if you have a different opinion, for the most part, mediations are today occurring in all caucus sessions. So the mediator as the mediator, then I have to do my opening then in every room I go into. So if I have a 3-party mediation, I give my opening 3 times. I will go in, give my opening. It's basically what is mediation. As we already discussed, I talk about an important point I like to make is that we're here to settle your case. That means you don't have to prove your case to me, because a lot of times I believe in mediation, we lose time when people get very entrenched or parties get very entrenched in arguing their cases. So I like to go in, explain what mediation is in the opening session, let the parties know that while we're going to discuss their case, including some of the harder parts of their case, they don't have to prove their case to me. We're really looking to see if there is a settlement. In the cases I do, civil cases, it's generally just always a settlement number that will get the case resolved for all parties. I also like to give an overview of the mediation, what the day will look like, how we'll be going back and forth to different rooms. I encourage parties to take their breaks while I'm out of the room. If there's multiple parties, I can be gone from one room for an hour or more. So I like to let everyone have an overview of how the day will work. I think part of that as a mediator, I also look at who's in my room. If I'm in a defense room with a defense attorney and corporate representatives or corporate counsel or insurance adjusters who have done multiple mediations, I don't need to give as much of an overview. I may have a plaintiff or also a defendant who is not regularly attending mediation, and I will spend a little bit more time with them explaining what the process looks like. I do invite all the parties to give an opening statement in the opening session. That is usually done by the attorney. That's my experience. Sometimes the plaintiffs will give their version of the story, which I find very helpful as a mediator. So if you're an attorney, I encourage you to allow the party to speak in mediation. I think it really offers them an opportunity to be heard. I think it can be very helpful. My experience nowadays is that attorneys tend to do the opening statements, but I, as an attorney, would encourage you to let your party do that. Of course, these sessions are confidential, and one of the other things I do in the opening is always assure the parties that I will not take something in the other room without their permission. And I, very true to that. Whenever I hear something that I want to share in the other room during a mediation session, I will always ask permission to take that into the other room. Okay, so moving right along, after the initial opening sessions with my opening and the party's opening, we really begin negotiations. Typically, the opening demand comes from the plaintiff, and then the mediator takes that into the defense room, and there really is a bit of back and forth. And with the numbers throughout the day, it's a little more than as we're all talk about shuttle diplomacy. It's a bit more than that. As we get into the negotiations, there's, all different types of conversations that a mediator is having with the parties surrounding the numbers. The facts of the case, of course, the law, and we're going to get into this, I think, in a lot more detail. So I'm just going to leave it as that the next step in the mediation is the back and forth negotiations. The mediation then will either end with an agreement or a non-agreement, and there's lots of other things we can do if we're at a non-agreement, and hopefully we'll have some time to talk about those, but different tactics that can be tried, such as bracketing and mediators' proposals, if there is not an agreement. If there is an agreement, the parties will typically not have all of the details of agreement, and for the civil cases that I do, the parties will most likely settle on a number, and I, as the mediator, will have the parties convey that number to each other in an email while we're all still on Zoom, and have the other parties respond that they accept that number so that we have that number in writing. And then one of the parties will agree to create the formal settlement agreement and release and get that out to the other parties, usually within a week. If the case does not settle, it is the mediator's job, I believe, to continue to follow up. Many cases settle in follow-up if they do not settle in mediation. I think that has a lot to do with people's expectations and having to adjust their expectations. And sometimes they just need a little bit of time to really digest what has happened at the mediation, to revisit the fact that their case did not settle. And I find that conversations in the week to even up to a month following the mediation is when you do see a lot of cases get settled. And that is our overview of the mediation process. Mark, would you like to add anything?
Explain, or maybe you can briefly explain what how a mediator's proposal works. I can do it, or you can do how you do them.
Sure, and we can even both explain that. So what a mediator's proposal is, and there's different ways of doing it, is if the case has not settled, very often I find parties ask me for this, even more than I offer it. But they'll ask for a mediator's proposal. I do mine by, we'll conclude the mediation. I look at the numbers, the last offer, by defense, last demand by plaintiff, and I try to determine where there's a number that both cases will settle. And I think the most important aspect to understand is I'm not putting my opinion on what I think the value of the case is. I'm trying to identify a number that I think both parties will accept. I then send an email to each party separately. It's very important that it's separate. And I simply offer, say, this is my mediator's proposal, and I just give them a number, and they're to only respond to me. And so what happens if, let's say, plaintiff accepts and defendant turns down, I just tell both parties that there is no agreement. And so that way, the defendant who turned down the offer does not know that plaintiff has accepted that number. And so that way, their negotiations can continue without harming their negotiations. How about you, Mark?
Right. I generally will discuss the number that I'm thinking with both sides. And there are two main ways of doing them. I think one is an evaluative approach where the mediator acts as if they're omniscient, perhaps, and says, I know this case should settle at this number because this is what the case is really worth. I don't think of myself as omniscient in that regard. I just try to come up with a number that I think is the lowest amount that the plaintiff would take and the highest amount the defendant or defendants might pay, something that will work towards settling it. And it is real important to stress to the parties, as Jennifer was just saying, that neither side, it's a blind way of doing it. It's double blind in that if one side accepts and the other doesn't, the side that did not accept doesn't get to learn that the other side did accept it, so that it doesn't ruin their bargaining position. And that's the main thing. And sometimes I've actually had some success sometimes on occasion doing one where they have 10 minutes to decide. Other times it's obvious they're going to need more time. For example, if an insurance company is involved and the adjuster that's present doesn't have authority above a certain amount, they may have to go back to roundtable it. So sometimes the sides ask for a week to decide, that sort of thing. And obviously I do whatever they want in that regard, how much time will work for both sides. Thank you. Back to you, Jennifer.
Yes, all right. And so that concludes our discussion of the overview of the mediation process. I guess we can also talk about what bracketing is. Bracketing is another strategy when the parties are at impasse, or meaning they're not reaching an agreement. And essentially, you negotiate two numbers. So if we use very basic numbers, because I'm not writing things down and I can get confused when I'm not writing things down, is like if if plaintiff agrees to bring their offer down to 100,000, then defendant, if plaintiff will bring their offer down to 100,000, if defendant will bring their demand down to 100,000, if defendant will bring their offer up to 50,000. And so you're narrowing the numbers that the parties are negotiating, and then they might come back and negotiate a second round of numbers. So, if defendant will bring their offer up to 60, the plaintiff will bring their demand down to 90, and you keep negotiating the difference until sometimes they keep negotiating brackets until they get to a number. Sometimes the brackets stop and they, just go back to more traditional negotiating. But what happens is it's when I find when the parties are sort of stuck and no one's really willing to make a move, and so the brackets sort of mobilize the negotiation. They're very helpful. A lot of times attorneys will ask for brackets right away. So, we might come in and, plaintiff demands $1 million and defendant offers 5,000, and someone says, how about brackets? And my experience is brackets are not going to work at that place. The parties have to be sort of closing in on an agreement and just be stuck in order for brackets to be effective. I find when parties are very far apart, there's still a lot more discussion to do on the merits of the case to get them into a range where brackets will work. But brackets can be very helpful. I had a case recently that as soon as we started working with brackets, the case settled within like 30 minutes, just going back and forth on brackets. I had two very motivated parties. That's not always the case, but the brackets really sped up the process and can be very helpful. Any thoughts on brackets, Mark?
Yeah, I just often I'll have one side propose a bracket, either because I mentioned it or they want to do that, and the other side can offer a counter bracket. And one important thing about brackets, as using Jennifer's example, $150,000. Obviously, the midpoint is 75,000, and you as a litigator need to decide or need to know that if you should be asked by the mediator, and I always ask this to be sure, that if someone's proposing a 50, 100 bracket, would they either accept or pay the midpoint of 75,000? Because I think a lot of attorneys assume on the plaintiff side, for example, that if the defendant says, if you'll come down to 300, we'll go to 100. Well, that must mean they're willing to pay 200. And that's not always the case. You always want to clarify that. and not just assume it as a mediator. And it's also, you should probably be sure of that when you're proposing a bracket or agreeing to a bracket. That's one thing. And also, if you have multiple defendants, for example, you could try the bracket with a collective party. Sometimes they only want to offer together, and sometimes they want to do a joint number to the plaintiff or plaintiff's group.
Okay,
Thank you. Would you like to move on, Jennifer?
that sounds great. What do we
Okay.
have next?
Ripeness.
I've been asked to talk about ripeness for mediation, and obviously the first thing is do both or all sides have enough information to settle the matter to go to mediation? For a plaintiff, for example, are your client's injuries resolved or the damage established so that you can make it an effective demand? Sometimes the injury is so ongoing, you may not be able to. I had a case that was going to set for trial, and it involved a brain injury, and we had to make 3 motions to continue. The judge was very difficult about it at that time. Sometimes the courts are more into easier giving a continuous than others, but the plaintiff attorney said it was a young person, and he wasn't even in a position to make a demand until there was more medical certainty. So that in that case, obviously, you're probably not ready to go to mediation unless there's a very limited amount available. Obviously, defendant has a small insurance policy that you would think in a case like that, it would probably settle, but you may need to go to mediation just to convince the other side quickly to just pay their limited policy. The other thing is, what are the residuals clear? Do you know what your client is going to be left with as a result of the injury? And on the defense side, do they have enough information to evaluate the matter, what their liability aspect looks like, and what the plaintiff's damages are? Obviously, this can be different in other types of cases, or a construction accident or construction defect case in particular. There may be ongoing problems and that sort of thing. In cases like that, on occasion, for example, if you have a case involving ongoing damages such as a private road that is subsiding, and there's a problem and it's causing problem for the various owners of that road, they may want to go to mediation early before they're fully ready to litigate the matter, just to see if they can come up to have a mediator assist them come up to an agreement as to what percentage of contributions they may be to try to get the matter, the road fixed before there's further damage done, and then they can continue to litigate or mediate the final resolution of how much each party would owe on that. Another question in terms of ripeness is your discovery completed, or at least in such a state that you feel safe and going to mediation? When I feel safe, is there, for example, if there was a pivotal witness who hasn't yet been deposed or statementized, you may not be ready to go to mediation because they may be very important, for example, on a liability issue. So if all the depots have been taken that need to be taken for you to be in a position where you can settle your case, and that's true from either side. For example, on the defense side, they may feel it's important that they get the plaintiff's deposition done before they mediate. It's also as an aside inspection, depending on the type of case. Do you need discovery with this? Discuss the discovery with your experts. Obviously, experts become very expensive, so it depends on the type of case. Most cases, you can probably mediate before you're involved with experts, but there's some that you would obviously need to work with an expert, such as a medical malpractice case, which Jennifer obviously has been involved in as well. Sometimes cases are ripe rather early and even before litigation has begun. And in that context, one example would be sometimes you have a case where there are numerous people suffering, say, a multi-car accident. There could be 10 people or more that were injured, and there may be limited funds on the other side. So I've mediated numerous cases where the insurance company comes in and says, hey, we have a X policy, we have a $100,000 policy, and we've got these 7 claimants, and we need you to work on getting them to agree, because they can't pay out to anybody until they get the matter fully resolved. So my job as a mediator in that context is to try to get the parties to agree to a distribution of that $100,000. And that's something that both sides would normally be happy with. Sometimes the people are still, some of them are still in pro per. I also gave that example before of a landslide, something like that nature. So that may be ripe for mediation before. And that's those are the main issues when you're trying to determine if your case is ready for mediation. Jennifer, I don't know if you want to add anything to that.
Well, you make great points, Mark, with some really good examples. I guess the only other thoughts that I might have are, it's really important. This is a really important concept to consider when, as an attorney, you're scheduling mediation. I think we've all seen many, many cases that come to mediation, and when the discussions aren't as productive as everyone would like them to be, then we start hearing, well, once we take so-and-so's deposition, and, you know, once we have this document, and it can be a little, you know, counterproductive for the case not to be ripe for mediation. And mediation is, you know, mediation can be costly, and it's really in the party's best benefit to be very prepared for mediation. And when parties can come in and are really able to address every aspect of the case, you definitely see improved resolution rates. And, you know, the other thing is, mediation is, it's really an art, and it's not as regulated as litigation, where, you know, litigation, we have the Code of Civil Procedure that sets forth all the timelines for completing the various aspects of discovery and trial preparation. And mediation, although you have mediation completion dates, other than that, mediation really is an art form. And so it's important that the parties are ready to resolve the case. I've had cases where in the first session, you know, there's just still a lot of very upset people, and a lot of things are up in the air. But as, you know, discovery progresses and trial dates start, you know, really causing, you know, emotional distress, because they really do stress people out, and the costs of case become real, then you can also see, you know, cases becoming much more ripe for mediation. So it's really finding the sweet spot of your case being prepared, as well as people realizing it's time to get the case resolved.
Thank you. I think
Yeah,
we'll move on.
you mentioned also like in a personal injury context, the defense may be waiting to get have an independent medical examination or a defense medical examination, whichever you wish to call it, done beforehand. And then you'd want to see that both sides have the report so that they can be prepared for the mediation before you proceed.
Thank you, Mark.
You're welcome.
Our next topic is about choosing the mediator. It looks like I have skipped, or it doesn't look right. Choosing mediator. That looks a little bit more up to speed. Did Mark or Jennifer, which of you had decided to speak? I had Mark down to speak about this topic.
It's actually Jennifer.
Oh, it's for Jennifer. And so
Okay. We'll
go
tag team.
all right.
So, choosing the mediator, again, this is, you know, more an art than a science, for sure. It's important that attorneys have a mediator that they feel comfortable working with. And so what are the qualifications of a mediator? I guess that would be what is important to the attorneys and a party on the case. There's various qualifications. That it could be subject matter expertise, it could be years of experience, it could be number of cases mediated, resolution rate. There's all different aspects as to what makes a good mediator. It can also simply be rapport, somebody that when the attorneys talk to the mediator, they feel like this is a person who gets where they're coming from and can have conversations with each party and ask the right questions that will lead the parties to a resolution. So my comment on the qualifications are they really vary. And I think to different people, different things are important. I certainly see that in the cases I mediate when parties will say, oh, I knew this about you, or I see that about you. And it's always something different. So I think there's definitely different things that are important to different parties. The best thing that I would recommend, and I think this is a benefit to the attorneys as well as the mediator, is having a call prior to scheduling the mediation to just see if it's a right fit to mediate the case. And that can, be from availability and thoughts on how the matter might be resolved. So I think it can really be all over about qualifications, but there are all types of mediators and different places to find mediators. So in terms of where mediators are at, there are panels. Like we all know that there are several private panels in Southern California that employ many mediators. There are also independent mediators. And so, for example, on this webinar, I believe Mark is a panel mediator with ADR Services. I am an independent mediator. I work privately. And I think private mediators really became much more common after Zoom, with most mediations moving online. In addition to sort of the private sector where you have panel and independent private mediators, there are court-appointed mediators. The courts have many different programs. I'm involved with one of them, which is the Mediation Center of Los Angeles, which has a referral program from LA Superior Court. In that instance, the mediators are paid, but the court will refer cases to the panel. And then there are also court-appointed mediators. I'm sorry, I don't know as much about them, but I know that there's programs in the appellate courts. I know small claims. I'm also involved in volunteering to mediate small claims. I've been doing that for years through the Center for Conflict Resolution. So those are your court-appointed mediators or volunteer mediators. So there are mediators in many different places. And if I'm missing anything there, Mark, please jump in.
You're doing fine. There's also Resolve LA,
Yes.
volunteer. And on that one, you get two mediators. I've been involved doing those for the court. And as Jennifer said, there's numerous programs, and you can go on websites and look at what they have to say about a particular mediator, with whether it's a private mediator like Jennifer or someone on a panel such as myself. They give you a little bio on there and some views on the cases they may have handled, that sort of thing. And word of mouth is also obviously very helpful as well.
Yes, definitely.
Very
All right.
good. There are no other comments on the choosing mediator. We can move on to preparing for mediation, which is a very big subject and something that we want to focus on for new attorneys who are new to mediation.
Okay, I was asked to speak on this, and I think just like preparing for trial, I think preparation for mediation is the most important, or one of the most important aspects of it. I always believed as a litigator and that I'd never wanted to go to a mediation, a mandatory settlement conference, or a court hearing and be asked a question I couldn't answer. And you never really don't want that to happen to you. It's very important you know your case backward and forward when you're going to mediation. I was doing a mediation not too long ago in a personal injury case that had two different plaintiff attorneys from two different firms, both representing the single plaintiff. And when I asked one what their medical bills were, he didn't know. He turned to the other attorney, and he didn't know either. That I think was embarrassing for them, and it's doesn't really give a mediator a strong feeling that they know their case very well, and it makes it a little harder to go into the defense room and say with a straight face that boy, they're ready to go to trial. They're really ready. They know they know what they're doing here. You want to show a litigator that you're ready to proceed with further litigation, and that you're ready to proceed to trial if it gets that far. Now, the contrast, it was also another slide about the contrast with litigation. There are many contrasts, obviously, besides the expenses. Trial can be nerve-wracking for the client as well as the attorneys on occasion, I suppose. And one important thing that I always mention at the beginning of mediation too, when I'm talking to the plaintiff or whichever, either in personal injury case or any type of case, but this probably matters more in personal injury, is that a trial is open to the public, generally speaking. I'm sure there's some instances where a court is closed, perhaps more in criminal cases, but normally they are open to the public and anybody can walk in off the street, walk in and watch the trial. And sometimes there's some sensitive issues in people's medical claims, medical history, that sort of thing. Perhaps the biggest issue is the time delayed and the delayed results of going to trial as opposed to getting a case mediated. I don't know how many of you, I'm sure most of you watch TV and watch various legal shows perhaps, and there was a show called Suits that was several years ago, and then with COVID and what have you, it came back on, and I know that had a big viewership. My wife and I enjoyed the show quite a bit, but it was very interesting that in that case, a dispute would arise, lawsuit filed, and the very next day they were in trial sometimes. In real life, obviously, at least in the LA County area, certainly that's not the truth. That's not what happens. Cases now are going to trial, I understand from the date of filing, anywhere from 18 to 24 months, and with numerous continuance, often it's much longer than that before you get to trial. That time gap, if you will, has seesawed back and forth through the years. When I first started back in the 1979, cases were only getting to trial. There was a 5-year rule, and cases weren't even getting to trial unless they were about 4 years and 11 months old. Eventually, the courts got so jammed up in LA County that they came up with what they called a legal fiction, if you will. They ruled that the cases, it was impracticable to get a case to trial within 5 years, and you had to sign things, and then you would be going to trial after the 5 years. They essentially extended that 5-year rule because they were so jammed up. There have been periods where cases were going to trial within about a year, but that was before COVID and before there was some funding gaps, and they opened up a personal injury hub and that sort of thing, trying to move cases along. So that seesaws, but your client has to realize that mediation, you may be able to get the case resolved much quicker with much less expense, much less angst, if you will.
So we're kind of moving on to the subject. If it sounds like you're kind of moving into this area.
I think I am, yes. Litigation cost. There's risk, time, toll on client, et cetera. First of all, talk about cost. You and your client have to realize if you're going through litigation, there's numerous discovery costs involved. It's mostly time on your side, the time of the attorneys, and the client's time in helping you with the discovery, going through interrogatories, could be numerous sets, that sort of thing. The costs of depositions, both, once again, time, court reporters, et cetera. Expert costs. Experts can cost quite a bit of money. Some charge, for example, to bring a doctor to trial. I know it was basically 5,000 half day, 10,000 full day, and that's gone significantly up. I'm sure there's many that are charging 20,000 for a full day now. And it's expensive to have them, whether you have a technical expert. They may have to review an awful lot of material, and you get billed for that, and the expert depot costs. Now, trial costs are, of course, much higher. I think generally the thought is on almost any case now, it's about $100,000 in cost to go to trial. That also, there's the attorney's time involved in that and the client's time in court. And they have to realize they'll be taking anywhere, if it's a jury trial, most likely it'll be about a week, week and a half at minimal. And sometimes obviously much longer. I've had trials where more than a month long, of course. And they have to take that time out from their job unless they're going to not appear at trial. But obviously, it's best to have your client appearing throughout the trial because the jury is wondering why they're not there when the jurors are spending their time. You also have to pay jury fees. You have to pay court reporter fees and the expert fees, which, as I say, can be very high depending on the case. The last trial I did that we had well over $100,000 in cost on that case. I think it was in excess of 150,000 actually. Additionally, going to trial is something of an emotional toll on most clients. Some are fine and happy to be there. Others are nervous, even when they're not going to be testifying, but they're very nervous. And I've had clients report sleepless nights, shall we say.
Jennifer, did you have any comment on those subjects?
Yes, of course. Where are we at on our slide? So I don't want to skip anything. I have some, we got to the briefs, or is that still coming?
That's still coming. That's
Okay.
coming. Well,
All right.
we've talked about the contrast with litigation and then this slide for the most part.
Okay. No, I mean, I don't think I have anything I guess the one thing I'll add is Mark is making amazing points about all the costs and people's need to appreciate the cost. So the biggest thing is coming to mediation with the attorneys and parties understanding present and future costs. I think it is impossible to make an educated decision at mediation without a thorough understanding. And as an attorney, it's really the kind of stuff that can come back to bite you. So for example, if you are in a mediation, I feel sometimes in mediation, there's a lot of sort of big talking without a real dial down into the cost. So example, people are talking about, settling a case for $250,000, but what does that really mean? And if there's $5,000 in costs and it's settled, and so the attorney's fees are paid and 5,000 in costs comes out, then the party, or assuming this is a plaintiff, can get a good amount of money. But if there is already 150,000 costs, and trust me, if there's been numerous experts and depositions and traveling for depositions, these costs can go up very high. You may have a plaintiff that agrees to settling a case and that is very upset when they see what the actual amount that goes into their pocket is. So I think to come to a mediation and to really have good discussions about how to settle a case, an attorney really needs to have a pre-mediation session with their client where they say, here is, it can very easily come off their case management systems. This is what we spent today. So this will have to come out with fees, or if it's defense, then the attorney's fees are already separately billed. And this is my projection, as Mark was explaining, of what trial will cost. That way, when there's a number, and this is when you get out, if we're going to get to this, but where we talk about the BATNA, or the best alternative to a negotiated agreement, where parties can really come into a mediation. And when there are numbers being passed back and forth in negotiation, they can really mean something, because it's not just a number going back and forth. Okay, that sounds good. That doesn't sound good. Parties can really understand how much they will either pay to settle the case or how much they will receive upon settling the case. So I think it's really very imperative that attorneys properly prepare their clients in terms of the dollar numbers.
I can't agree with Jennifer anymore. Then she's made a great point. And one thing that often comes up in mediation is they're talking about a number, say in the plaintiff room, and they've got to realize that to receive the same amount at trial, they have to get a verdict far in excess of that, because there are going to be costs that come out. Now, sometimes costs are recoverable, but many times costs are not recoverable from the other side if you win. And that goes into statutory offers to compromise, et cetera, which I don't think we're asked to cover in this one, but that's something you have to think about as well. Should I go on, or do you want to add anything to that, Jennifer?
No, thank you.
Okay.
Okay, let's see if we're getting, yes. Guidance from the client or from your senior attorney. In this case, we think we may have a lot of new associates in the audience, or associates with only a few years of experience. And so that can be an issue with speaking to the senior attorney. We also just have issues about getting guidance from the client.
Yeah, I think as Jennifer is saying, it's important to have met with your client. Obviously this could arguably on phone or Zoom, or bring them into your office or meet them however, or wherever you want to. But you need to discuss the client what is reasonable to expect at the mediation. And you have to have an agreement on what you're going to be, is your opening demand or opening offer, depending which side you're on. And this is something you may, as I say, as Dan was just saying, if you have a senior attorney in your firm, or just a client, a friend that's a senior attorney, or a colleague in your suite or floor, wherever you may be working from, you may discuss with them or a couple people what's a reasonable resolution of the matter, what a reasonable place to start with either your demand or your offer. Often I have cases come in where people come in and make a $5 million offer because that's what they know the insurance company's policy is, when a case is clearly not worth, and they know it's not worth any more than $50,000 to $100,000, but they want to start at $5 million. Sometimes I think it's because they want to show their client they're asking for every penny they could possibly get, but that can often slow things down. Often in response, the defendant then, well, if they're going to be at $5 million, then we're offering $5,000, even though they know the case is worth significantly more than $5,000. And that's true on both sides, that it takes a while to get back to get more into the realm of reality for both, where you're getting reasonable offers and reasonable demands. Sometimes people come in with nothing new happening, and they've suddenly doubled their demand from the last one they'd made. And sometimes that makes sense because there could be some additional injury, additional medical treatment, that sort of thing, if it's a PI case, or additional damages if it's another type of case of contractual or whatever it may be. But there needs to be a reason if you're suddenly greatly increasing your demand or lowering your offer to start the start of the mediation. But it's just not helpful to start at a very high, ridiculously high number. Although you do want to, of course, leave yourself room on the plaintiff side, and same is true with the defense side. Obviously, if you were very close, then you wouldn't need a mediator, and you would just get the matter settled between you if you're $5,000 apart or something of that nature. But starting significantly too high or significantly too low can really slow down the process and make it difficult to get the matter settled. And you need to explain that to your client as if you aren't going to ask for something extreme, as to why it's best not to do so. In terms of documents, this is extremely important. You want to make sure that anything that's not privileged or not going to be used for impeachment purposes has been shared with the other side. It's very slows down the process and makes it almost impossible to settle when somebody comes in, for example, in a personal injury context. They come in and the defense side thinks the plaintiff's medical bills are $50,000. And then the plaintiff attorney says, oh, well, she just had surgery 2 weeks ago. Now our bills are $250,000. And the same is true on the defense side. If they have for example, a defense medical report and they haven't shared it yet, the plaintiff may need time to digest that, go over it with his client, discuss what this doctor had to say, that sort of thing, that nature. The same is true in just about any type of case. But for example, in a case where there's an insurance policy involved and the plaintiff attorney surprises the other side with a new surgery, new spinal cord stimulator, whatever type of treatment was done, greatly inflating the medical bills, that's a real problem, because typically on the defense side, if you have an insurance company, the adjuster will come with a preset, if you will, spending limit, or he has authority, she has authority up to a certain level. But if it goes beyond that, they need to speak with other people. In particular, once these new documents come forward, the attorney on the defense side will have to analyze them, do a report to the carrier. Then the adjuster has to go through them, look at them, has to then take it up to his supervisor, her supervisor. And if it's a big enough matter, it'll get roundtabled. There could be several different levels. And the same is true if the city or another institutional defendant is involved. They may have several levels that they have to go through with supervisors, even the board, something of that nature. So it's very important that you've shared all those types of items with the other side. And the same is true on the defense side. They may have something from an expert that they can share. Share at the with the other side. That's going to greatly lower their expectation of what the defense would be willing to pay and the good reason for it. Move on for a second. As I say, springing new material on the other side is a big problem. Now with briefs, you want to be very thorough in your brief, but not overly long, if you will, for most people. It is a brief after all, and sometimes you get ones with 100 over 100 pages. That's probably too much, but you want to get forth the most important information you have, your theory of the case, why your case is worth it, what the damages are, or vice versa, why the reasons are that you're not going to be paying, your client isn't going to be paying what the plaintiff attorneys are asking for. So you want to lay out your arguments and some supporting information for your arguments, whether it's as to the injury or as to the lack of liability on the other side, or why you don't think the plaintiff's injuries or damages are what the plaintiff is claiming, and it'd be difficult to prove it. Now, we're also asked about, one second, this. Sometimes people come to mediation to settle, and this goes in your brief, and what you'll be putting in your brief too. You hope, and as the mediator, you really want to settle every case that comes before you. And I think luckily, a rather substantial percentage of cases come to the mediation where both sides actually want to get the case settled. Sometimes people seem to go to the mediation just to puff out their chest and talk about how great their case is. And sometimes, occasionally, and this is often on bigger cases, they come in just fishing for information. They don't really necessarily want to settle at that time, but they want to spend some time, and they think they'll get some nuggets as to what the other side might have or what the other side is thinking. And sometimes people just come to mediation because they have been ordered by the court to go to mediation. And a lot of this would depend on your case status too, as to what you're going to put in your brief. Sometimes you'll have documents that may be great, such as impeachment documents, and you wouldn't obviously include those in your brief. Many mediators like both sides to share their briefs, and that's a big question, is whether your brief is going to be confidential just for the mediator's eyes, or if you're sending a copy to the other. I've had people do it both ways. I think it's helpful perhaps to share it with the other side, but sometimes you want to have information that you don't want to share there. The main thing is, in your brief and in meeting with the mediator, talking to the mediator in the caucus sections, you want to give the mediator ammunition to have him help the other side understand where you're coming from, essentially. You want to be able to say in the defense room, you want the mediator to have ammunition as to tell them why they need to look at the case through the plaintiff's eyes, essentially, and why the case is worth far more, perhaps, than they thought coming in, what that information would be. And the same thing is true on the other side. The defense wants to give some information to the to the mediator to help lower the plaintiff's expectations, to have it explain to the plaintiff why the case may not be worth what they thought it was, and just to get the parties closer together and see if the case can be resolved. Now, sometimes you may have some information which I would call some dynamite evidence. For example, that could be a sub rosa. If you're on the defense side, you may have some sub rosa film from a plaintiff that says they're wheelchair bound. Maybe you've got film of them doing jumping jacks, whatever it may be. Sometimes there's lots of different examples of this sort of thing. And the same thing can be true on the plaintiff side. You may have some information, a witness or something that hasn't been disclosed that would shatter the defense theory of the case. Now, occasionally you may have an attorney on the other side or attorneys on the other side that you trust. And I can tell you that through my years of practice, I had ones where I could actually call him up and, hey, Bob, I've got this. And he would trust me, and actually the case would get dropped or settled for something very little. But there's other times you have a very realistic fear. My last trial was this way, where I had some stuff that I would clearly say was dynamite evidence. It was, and I will tell you, I had a plaintiff who was claiming she was very severely injured, claiming a brain damage, claiming that she lost all sorts of physical abilities, et cetera. And I had Instagram photos showing her standing on her head. She said she used to address groups of 20 people, and she could no longer do it because she was too shy and would get too upset. And then I had an Instagram post where she talked about how fun it was talking to a convention of 1,000 people, et cetera. And it goes on and on. And that's something I just knew that this plaintiff attorney, and this is what I was going to say, you can't necessarily always trust him. And I had the clear impression that this attorney would just use that material to try to exclude it in some way, or to try to soften the blow of what I was bringing out, or just be thinking of arguments in advance. But you can share stuff like this with the mediator, perhaps. And I've done this successfully too with a mediator or a judge, and at a back in mandatory settlement conference days. And you can share that with the mediator and have them say, I can't go to the other room and say, I can't tell you exactly what they have, but Mr. X, Ms. X has something that's dynamite that is really going to hurt your case, and I can tell you. And also the mediator can help you, maybe telling you that, well, I don't think you're going to be able to get that into evidence, or yes, yeah, I would expect that to come into evidence, that sort of thing. You can consult with the mediator on that sort of stuff. Now, I've been asked to address the consulting with the mediator, and some people like to talk to the mediator beforehand. I think Jennifer was suggesting that, and just in selecting a mediator. I don't usually have people do that, but it can happen on occasion, of course. Some people want to consult with the mediator. They want to call ahead of time, or just at the beginning mediation, to just say, hey, Mark, I have a difficult client. He's not seeing it this way, or I have a difficult adjuster, or what have you. And I need some help getting them to see the case as I do, that sort of thing. And that's something you can certainly consult with your mediator. Another thing in issue of consulting with the mediator, when you're dealing with an individual, when you're on the plaintiff side, some attorneys I've found want any offer that's made to come to be said to them in front of their client, to be discussed fully with with both of them or multiple plaintiffs, and to have them hear everything. Other attorneys don't want their clients to hear it. They want to be taken out of the room or talked to in private about well, now they're offering you X dollars, and they don't want that done in front of their client. And so you should let the mediator know what your preference is. I try to ask people whenever I start a mediation which they prefer and how they like going about that. Now, of course, another important aspect is preparing your client for and managing expectations. And that we talked about, or I talked about it when you were discussing about the original meeting with your client, or the pre-mediation meeting, I should say, and discussing it with a senior attorney or just, a colleague. They could even be the same level as you. And I'm sure people I know, I would always talk to other attorneys about cases. My wife was a practicing attorney with me for a long time, and she started mediating full-time 20 years ago. But we'd still discuss cases regularly, as you'd expect. But it's important to talk to your client that they may say, and I will tell you, one thing, many years ago, I had a case, I was defending a retailer, and there was a slip and fall accident, and they had it settled for $10,000. At one point it came to me, because then they turned it down. And the guy told me that his client had agreed to it, but then they watched an episode of the People's Court or something like that, or Judge Judy, and now they knew their case was worth at least $100,000. And you may run into that from time to time. So it's important to talk to your client about the realities of litigation and manage their expectations that, hey, they only have X policy limit. You can't get you'll never get more than that from them. you can talk to them, or they may be individuals, or they may be an excess policy, or maybe you're dealing with a defendant on the other side that does in fact have assets. But you have to understand the realities of their injuries, the realities of their claim if it's a different type of case, contractual issues. A contractual case, you got to talk about that, what the other side might be able to pay. Sometimes you have to work out essentially a payment plan, that sort of thing. But it's important to discuss that with the client, and you may know that the other side isn't going to be able to afford what you may think the case is worth, but they may want to work something out with, like I say, a timeline with payments coming and something of that nature. And you should fully discuss all of that with your client before the mediation. Thank you.
Mark, thank you. That's a wealth of information. I wanted to leave a little bit of time for questions if we had them. Craig Lang has been monitoring some of your questions, and I just want to check with him to see if we had anything we need to bring up now.
Yes, no, as of right now, there are no questions, although I do invite, any participants to place them in the Q&A. So, go ahead if you have any. Otherwise, right now, I don't have any questions.
Well, first of all, Mark has addressed such a wealth of information in the last 15 minutes, and I wanted to get Jennifer to see if you wanted to comment on any of these points in the preparing for mediation.
Sure. I definitely appreciate all of Mark's expertise. So glad to have him with us. I can just tell all of the stories he has of all the cases, and it's a lot of it rings true for me as well. So I really enjoyed listening to it. All right, a couple of just practical things that came up as I was listening to see if it's helpful to our attendees. So the brief, Mark definitely touched on the fact that the brief can be either confidential or shared. We all, as mediators, handle things differently, so I'm just giving you my 2 cents. I ask parties, please share your brief, because there's nothing for me coming to a mediation and then, the other side doesn't even have really any understanding of the of their opposing counsel's theory of the case. And just from a psychological perspective, I think parties need time to analyze and to hear the other side's position and some time to digest it. And when you're doing that in mediation, it can get a little tricky. So I actually highly encourage parties to share briefs, but then I also, say if it is really important for you for it to be confidential, then give me a confidential brief. But I think it's really helpful to share briefs. On that being said, another thing I think is just a tip for attorneys. A lot of times I'll get a brief and it'll be, 4 pages on the law and then gets into the facts. But a lot of times if it's, for example, a medical malpractice case, maybe we don't need 3 pages on the law if there's no disagreement as to the law, when there's really just disagreement as to the facts and whether there is, negligence and causation. And so really focusing in on what needs to be resolved to settle the case. I think it's a great idea to please give the mediator a settlement history. Have there been demands and offers, 998s? Where are things? Because I think Mark also touched on this. We don't, want to start a mediation with some number out of the blue that has nothing to do with the settlement history. You're really going to take your case backwards. Asking your senior attorney for guidance. I think this comment is from when I was doing defense work. You're going to have, if you're doing defense work, you're going to have the same clients again and again, whether they're the adjusters or the corporate representative. So you want to get guidance from the senior attorney on, again, there's different personalities. Is this somebody that's going to expect you as attorney to go in there hard and, sort of like, really, pounding your fist and defending position? Or is this somebody that really wants to get in there and start offering numbers and being really collaborative? You really need to, because you are sort of balancing, if you're a more junior attorney and you're working for a senior attorney and you've got the client, now you're working with the mediator to get the case resolved. There's a lot of things you're balancing. And so that's a really good place to get guidance. And that would be for a plaintiff as well as, what is this client about what type of, do they need hand holding? Do they want to, sort of drive the mediation bus? I've had, I recently did a construction case, and it's the owner of the, construction firm talked, for the majority of the mediation, because it's, a business person and had very strong opinions, where other times I'll have people that sit with their heads down and their attorney does all their talking. So you want to understand the clients. Also, last thing, I think Mark really touched on this as well, is if you have a convening call before the mediation, tell the mediator what's up, so that they can help you. If you have client control issues, let them know so they know to address this. I recently had a convening call with an attorney who told me, look, Jennifer, I'm really sorry, but my client expects me to be a bulldog. So I'm going to be a little crazy in the mediation, but let's talk. Text me, whatever you need. And so that helped me, because he was a totally different person in the mediation than he was in our outside conversations. But what he told me, so I was like, okay, he has to do this, fine, I get it. And then I could work with that to help get the case resolved. The other thing is, when I was a very young attorney, I worked with this really wonderful trial attorney who's, unfortunately no longer with us. But what he said to me, he said, Jennifer, every case barks. And I think we talked about this earlier today, where Mark was saying that if it was easy to settle, that it would have already been settled. So there's problems with every case on every side, or else the case would probably already be resolved. And so there's hard facts, and you can't really hide from them. I think as a mediator, it's our job to say, to play devil's advocate, to talk about those hard facts to you. But you really need to come into the mediation as an attorney, understanding that there are some, it's unlikely that everything is going to be perfectly in your favor on this case, that there are some, probably gray areas where a jury or a judge could rule either, or, make a decision either way. And part of getting a case settled is sort of balancing some of those hard facts. So please be open to discussing them. And now is a good time to discuss them with your client too, because they're not going away. And that's on really all cases. And so that's my 2 cents.
Um,
Wanted to add that when you're going to a mediation, and occasionally, almost all of them are on Zoom now, but occasionally there's ones in person. But you really just want to show, if you're getting close to trial in particular, you want to show the other side you are really ready to go, and you want to show the mediator. I know one of the ones I did when I was I was normally on the defense side, but I did some plaintiff work too, and I had a very good plaintiff's case, and I came into the mediation and I had my evidence books ready to go, with full of the great pictures, et cetera, that was going to be extremely helpful at trial. And anyway, you just want to have a presentation like that and be ready. Even you're not on Zoom, obviously you're not bringing that sort of thing in, but you can just be able to talk fully to the mediator, explaining, what you've done, what you've got ready to go. You've got your experts lined up, you've got your witnesses subpoenaed, whatever it may be, to show that you're ready to go to trial. And one other thing I didn't mention, but I did want to, and this is not very frequently happening. It happens probably most often in construction cases, but sometimes there's actually mediations where you actually bring experts. This is normally, as they say, in the construction realm, where there may be multiple defendants, and the plaintiff may bring in an expert to present to everybody. This would be done in, like, obviously a joint session, show what what they believe the defects are and why it means that. And then one of the defendants may say, well, here's our expert, Mr. Smith, and he tells about various aspects of why they believe it's different, et cetera, et cetera. Just basically making a little presentation to try to get the matter resolved. Thank you.
I have a couple questions now. The first is from Anonymous. How do you handle the fine line between giving legal advice, or better put, I've heard a lot of plaintiffs and private defendants ask if the settlement number is fair, or what the type of case is worth?
A lot of times they want to ask you what the case is worth, and quite often I've asked them if they are old enough to been before Judge Rich out in Riverside. You'd go in there and you'd go through the metal detector. His picture was on the wall, a portrait of him wearing a light blue cardigan sweater. And then you would meet him, and he would handle mandatory settlement conference in the hall with wearing a light blue cardigan sweater. Whether it was the same one or he had 50 of them, I'll never know. Anyway, when he was asked what a case was worth or if this was a fair settlement, his answer was always, and I heard it, various people ask him at various points, and he'd always say, well, here in Riverside, Mark, here in Riverside, John, whatever it was, Sally, we have a perfect system for that. We have 12 people that will tell you exactly what your case is worth. Obviously, if you're asked legal advice, you can't really give it. You have to tell them that you can't give legal advice. You may make suggestions or something and try to be helpful, but I agree there's a fine line and you just have to walk that line, if you will, I think. Jennifer, I don't know how you address that.
Yeah, same. I mean, often, it's not really what I think the case is worth, but a lot of times I get hunches from having done things and might tell someone, this case is going to have to get to the 6 figures to get resolved, because I can read the parties. And so it's not really me giving my advice about what the case is worth, but I know where we're going to have to get and for the case to be resolved. And I do think usually the parties appreciate sort of understanding that. Of course, they drive the bus in mediation and can make whatever offers and demands they like, but I do try to sometimes give them that information without really giving my opinion on what the case is worth. And I think the jury instructions are your friend in mediation, because that it's always everyone's always talking about we're going to go to trial. And so then if you're going to go to trial and put this case on, and then the jury's going to be given the jury instructions to make a decision on your case. So I always often I look at jury instructions and have the parties look at jury instructions, and it's not really legal advice, but that is, the decision-making process, and they can put their facts in context with the decision the jury will be making.
How are we doing, Craig? Do we
Uh,
have time for more, or are they going to
Yeah,
cut us
no,
off?
I'm good. I think I have one more question. I think we can, and probably hopefully maybe wrap it up after that. But
In case they do cut us off, please take the moment to make sure you have entered your name as it's listed with the bar, and your bar number in the chat section. And we're just going to go. We have a lot of material here, so we're going to go until they cut us.
okay. Well, I would say you have I have one more question for also anonymous. But it's the question is, do you give templates for the briefs or let the parties draft their own without a template? And a kind of tangential to that, do you normally have page limits?
I do not tend to give out templates. I think and I receive briefs that are sometimes, in essentially pleading format, like you would submit to the court on a mandatory settlement comments, or sometimes they're just in letter format, and either one is fine with me. I don't have a page limit. And sometimes, like I say, recently had one where I had 312 pages of exhibits that they added. That might be a little bit overkill, but I did go through them. Will not tell you that I read every single line of them, but I did look at all of them. But it is a brief. I know some mediators prefer, it really depends on your case, how much you really need. So I leave it up to the attorneys. I don't set any limit.
Yeah, same. I would say I don't set any limits or give a template, but I do ask for it 7 days in advance. And very often they're coming in the day before. If you really want your mediator to spend time on that, I think it's more important to get it out timely. And with attaching, some parties do just attach everything, the sort of the kitchen sink of exhibits, but if there's something really important, it can be lost there. Same if I have enough time, if I get it 7 days before, I will read through everything that's sent to me. But it is really helpful if you have some key exhibits. It's almost better. I think less is more. And I always say you can always send stuff email during the mediation if anything comes up.
Yeah, that's often I have people that want to share something and they'll email it they'll use the share screen, or they'll actually email something to myself and to the other side, or at least to me to just look over.
Doing, Craig?
All right, well, we're good. I think this is about it. I think we're running out of time as far as the recording is concerned. So I think we need to wrap it up. But I have no further questions. I do want to thank the panelists for their insight. It's been very very interesting, I think. And I'll leave the rest to you, Daniel.
That's pretty much it. I have to say, attendees have gotten a very comprehensive overview of the mediation process and things that you're going to need to know in your first mediation. And so I thank our panelists, Jennifer and Mark, and thank you for participating.
Thank you, Daniel. Thank you, Craig. Thank you very much, Jennifer. Thank you all very much.
Thank you, everyone. It's been a pleasure.
Thank you.
Thank you.